Good morning. My wife put an old post on relation to local government, and on came a Nigel Bradford. Well, when you tell half a truth and put it forward as a truth, it's still the same thing. It's a lie. I agree with the 1974 referendum. The 1988 one was to add local government. That's half truth because it consisted of four questions. Do you approve the continuance of local government? The people said no. Do you approve the establishment? The people said no. So, Nigel, why didn't you put the whole lot on? It's available when you bring up referendums, it's there. And the highest court didn't agree with my submission. No, that's a lie too. The highest court never heard my submissions. They used rules of the court to throw it out. And one of the things they threw out was their own decision to facilitate what the government rhetoric was. And that was the fact that the states did not exist before Federation. They were created under the provisions of 107, 108 and 109, quoting from Quick and Garron. The states under Quick and Garron 106 are allowed to retain their constitutions subject to this constitution. There was no ever power to alter the state constitutions. It was an assumed power prior to Federation, and your claim that those rights were allowed to continue from before Federation is absolute nonsense. It is a lie. Don't like that? Go read Quick and Garron properly. The Quick and Garron I'm referring to is the red one. The green one is exactly the same according to Anne Toomey, so I'll refer to the red one. That came first, and it obviously is the same according to Anne Toomey. Either that or she's not telling the truth. That doesn't surprise me. So let's deal with it. First of all, the state constitution, all of them, were made letters patent on the 29th of October 1900. So you misled people that way. You would have known that because it says on the front. The Commonwealth Constitution was proclaimed on the 9th of July 1900. Is that true? No. The Commonwealth Constitution Act, the Enabling Act, which enabled the people of the Commonwealth of Australia, the 6 colonies, to become states under the provisions of 107, 108 and 109. They draw their authority referentially from the Commonwealth Constitution. So, therein lies the problem with what you've been saying. The municipal authorities existed before Federation. So did local government. What was local government? It was the local government of the British Parliament. The 6 colonies had 6 individual parliaments, all subjected to the British Parliament under the Colonial Laws Validity Act. Read it and weep, that's the truth. There's nothing on your site, so I take it you're just another troll put there by somebody who thinks he knows nothing. Well, he's pretty right, he doesn't. Midland Junction Municipal Authority was in place before Federation. So was the Parliament of Western Australia before Federation, because that was a local government of the British Parliament. So, by agreement, the 6 colonies became one colony, as explained clearly in Clause 8 of the Constitution. Become one colony, didn't become an individual nation or anything else. On the 1st of January 1901, it was proclaimed and gazetted in Australia as the Enabling Act to enable the newly established Commonwealth under that Act to have its own constitution. Read it and understand. That's what it is. And Quick and Garron will tell you under section 51, subsection 38. Read the annotation. It's a page and a third if you can read that far. And you should be able to, given some of the things you've just said. Or you're probably already aware of it. There was only 7 legislative areas ever exercisable by the Australasian Council, and even less by the colonies, And all 7 of those are contained in Section 51 of the Constitution. So now we have a little problem from what you said, Nigel Bradford. You said the states retained the right to change their constitutions. They never had it. They never had it. Otherwise it would have been in Section 51. When you look at the first 260 pages of Quick and Garran, you'll find out what was banned from the new Commonwealth was conscription, preferential voting, political parties. And what banned your ability to change the state constitutions? The first thing, the fact that it wasn't in Section 51 of the Constitution, and that so the states had to rely on their own act. And according to the Constitution, it says at Federation, the states can retain their constitutions subject to this Constitution and altered in accordance with the Constitution. And therein lies the problem with you. Do you know that it was made letters patent? If you don't, go look it up. We've got it on our computer. Yeah, interesting, isn't it? If it was made letters patent, who can change a letters patent? Well, each state had a letters patent for the office of governor, and each state on their letters patent for the office of governor was given a fact that only the reigning monarch can change a letters patent, and they haven't done it. They haven't done it. So what you're trying to say is they had the right to create a local government. No, they didn't. They had to, before Federation, they had the right to create a local government, which is the local government of England. Now, if you go to page 936, which Anne Toomey conveniently took up after I kept reminding everybody, because they kept saying there's no local government in the Commonwealth Constitution. Yeah, there is. Quick and Garran, there is. It says, state legislative authorities, page 936, the 8th line down. The states have authority to set up municipal authorities and local government. They're 2 separate things. Why are they? Because the local authorities are the municipal authorities. They are the roads boards, the councils, whatever else you want to call them. They are a government entity there to do up the roads, footpaths, and issues like that. Lay out streets for town planning under a lawful act, which we don't have because it gives you authority over our land. They don't have it. And the local government is the state parliament. If that's not so, how come on page 701, and I'm not going to ask you the question because it's rhetorical, what you are understanding, if the states were granted the right to set up a local government, that local government would have to have 2 houses of parliament to comply with the Constitution. They would have to have a separate governor to comply with the Constitution. A representative of the Crown, it'd have to be there. You cannot just hand your powers to a government entity, which is literally one of ours. It's under the control of the public service. It's nothing to do with the Parliament. They are not the government. They are the legislature of the government. There is an executive, which is 10 from the lower house, 8 from the upper, of each state in compliance with the Commonwealth Act and Commonwealth Constitution. Is that clear? What you're trying to make out is they have all these authorities. They don't have them. And no amount of lies and fraud and bending and twisting and ridicule of people. Oh, look at that, you patronising little parasite. Tony, you don't understand. Actually, Tony does understand. So does Scotty Barr, so do the others. You are a troll. You've got nothing on your page except a picture of who you might be. I say that because it's probably more than likely not you. But even if it is, it doesn't matter. You made a lot of claims on there, and those claims were wrong. If you knew it, they were wrong, you're a liar. If you didn't do any research. If you had read what the High Court said, you would have found they used their rules to throw out the case because they didn't want to hear it. It came from three quorums: Wheeler, Pullen, and Buss. They were quorums. A quorum is an unelected judge, a person impersonating a judge who isn't one. Wheeler, in a case not long after they put my case through and they denied everything, they denied 4 decisions of the High Court. One of them was HCA 48 of 1996, which made what they said in their decision an absolute load of nonsense, lies and rubbish. Typical of those three jerks. That's all they are. Lying clowns. Not officers of the Crown. How do I know that? In Headley versus Spivey, another case I was watching, a friend of mine is the Headley part. I read his case. I read the decision that she wrote. I also read the transcript. I also was present when Wheeler, the head judge out of the three, or supposed judge who was only a quorum, said, I don't have to be under the Crown. I've got a commission from the government. Well, that's interesting because the state's constitution is very clear and in compliance with Section 72. The governor of the state selects all judges and justice of the peace, and they swear the oath contained in the Constitution. And they didn't do it. Because what was before them, from me, verbally, in their face, in front of a TV station that was there, trying to mock me, and they heard me say to them, under what authority are you sitting in this court? She tried to sidestep it. I said, no, you must sit under the Crown. Under what authority are you sitting in the court? And she dribbled on more and more garbage about this and that she knew nothing about or was concealing it. That doesn't worry me. So, it's a very, very interesting thing that at the end of it, I handed them 3 documents. And as Brian Shaw will attest to it, those documents for the arrest of those 3 quorums. For personating officer of the Crown, committing treason and misprision of treason, which is concealing it. So, Nigel Bradford, you want to go on the attack with people, you do your research and find out the truth. We've found out more and more and more truth by going back and finding out how many times the government has lied. Well, that was simple. It's continuous since Federation. But the fact of the matter is, you can't have local government. They asked us if they could continue it. We said no. Establishment, we said no. So even if it was in the state constitution, we could wipe it out by that referendum. That referendum, once it went through and the people said no to the continuance, no to the establishment, they can't have it. No lawyer, not even the High Court, can overturn it because the supreme, absolute and uncontrollable authority remains with the people. So, Nigel, you want to come on my post and tell lies, you better get your story correct and you better do your research. Quick and Garran doesn't say the things you said it does. You assume. Don't assume. Come up with facts. Because if there was an authority to change the state constitutions, it would have been in Section 51 of the Constitution. And it's not. It's the same. There is no control over land. They had the Transfer of Land Act before Federation. That was wiped out on the proclamation of the Constitution on the 1st of January 1901. Because on the 9th of July, that's when Queen Victoria proclaimed the Commonwealth Constitution Act 1900 UK, the Enabling Act. Read page 200 and 0 to 260. Read it, and then you will understand. You do not quote garbage like you are. The Constitution does not give the states, never did give the states, the right to change their constitutions. They were doing it. Western Australia passed an act in 1899. Where's that act now? It's invalid by transgressing the Constitution. Western Australia never complied with 106, never put its original constitution in place as a letters patent. They put it in with 32 sections missing. Western Australia has never been lawfully constituted. Guess what that does, Nigel Bradford? That fails to constitute the state of Western Australia. So because that didn't happen, and Western Australia did it, and in August 1902, New South Wales changed theirs, there's no federal parliament. Because it's the representatives of each state which created it. How did the federal parliament cover that up? Oh, they created the Commonwealth Electoral Commission. No. Go back and read the first 260 pages of Quick and Garran. You'll find out what was actually decided. And what was decided, the elections would be taken state by state. And it's the coming together of the representatives of those states which create the first lawful federal parliament. So nothing that took place after that was valid, especially in Western Australia. In August 1902, New South Wales negated their state. 1922, Queensland knocked out its upper house, wiped itself out. Alter is not remove or change. Perhaps, maybe, Nigel Bradford, you could go back to school and understand what I'm saying. Alter is not change and remove. It's alter one letter or something like that to clarify that particular section. That's already determined in law. And the Statute of Westminster Adoption Act alleges to have removed the Colonial Laws Validity Act, which it can't. Because when you read Quick and Garran, and if you are quoting from it, perhaps you should read it. Page 701 through 704, it'll state, even if that act had never ever been enacted, it was beyond the legislative authority of any colony to change or interfere or alter in any way an imperial act. What does that do to 106? Prohibits them changing it because it continues subject to our Constitution. Understand, I do a hell of a lot of research for the case of and provision of the truth from our Constitution. You want to stand up and lie about me and lie about what takes place, you better be better at it than you are now, because you're not. So really, Nigel, go back, crawl into whatever hole you crawled out of. Looks like you are a lawyer or somebody of that standing. If you are, if you're a judge or magistrate, you're a total moron because you don't know the law. You're forced by law to understand. You have no idea. And please don't go to Ann Termy. She wouldn't have a clue either. If she is, she's teaching the wrong stuff. Anyway, you have a lovely day. Have a good weekend. Have another go. I've got plenty of answers for people who can't tell the truth. Thank you.